California v. Hodari D., Supreme Court, 1991. Justice Scalia delivered the opinion of the court. Late one evening in April 1988, officers Brian McColgan and Jerry Pertoso were on patrol in a high-crime area of Oakland, California. They were dressed in street clothes but wearing jackets with police embossed on both the front and back. Their unmarked car proceeded west on Foothill Boulevard and turned south onto 63rd Avenue. As they rounded the corner, they saw 4 or 5 youths huddled around a small red car parked at the curb. When the youths saw the officer's car approaching, they apparently panicked and took flight. The respondent here, Hodari D., and one companion ran west through an alley. The others fled south. The red car also headed south at a high rate of speed. The officers were suspicious and gave chase. McColgan remained in the car and continued south on 63rd Avenue. Pertoso left the car, ran back north along 63rd, then went west on Foothill Boulevard and turned south onto 62nd Avenue. Hodari, meanwhile, emerged from the alley onto 62nd and ran north. Looking behind as he ran, he did not turn and see Pertoso until the officer was almost upon him, whereupon he tossed away what appeared to be a small rock. A moment later, Pertoso tackled Hodari and handcuffed him and radioed for assistance. Hodari was found to be carrying $130 in cash and a pager, and the rock he had discarded was found to be crack cocaine. In the juvenile proceeding brought against him, Hodari moved to suppress the evidence related to the cocaine. The court denied the motion without opinion. The California Court of Appeal reversed, holding that Hodari had been seized when he saw Officer Pertoso running toward him, that this seizure was unreasonable under the Fourth Amendment, and that the evidence of cocaine had to be suppressed as the fruit of the illegal seizure. As this case comes to us, the only issue presented is whether, at the time he dropped the drugs, Hodari had been seized within the meaning of the Fourth Amendment. If so, respondent argues the drugs were the fruit of that seizure, and the evidence concerning them was properly excluded. If not, the drugs were abandoned by Hodari and lawfully recovered by the police, and the evidence should have been admitted. In addition, of course, Pertoso seeing the rock of cocaine, at least if he recognized it as such, would provide reasonable suspicion for the unquestioned seizure that occurred when he tackled Hodari. We have long understood that the Fourth Amendment's protection against unreasonable seizures includes seizures of the person. From the time of the founding to the present, the word seizure has meant taking possession. For most purposes at common law, the word connoted not merely grasping or applying physical force to the animate or inanimate object in question, but actually bringing it within physical control. A ship still fleeing, even though under attack, would not be considered to have been seized as a war prize. A res capable of manual delivery was not seized until taken into custody. To constitute an arrest, however, the quintessential seizure of the person under our Fourth Amendment jurisprudence, the mere grasping or application of physical force with lawful authority, whether or not it succeeded in subduing the arrestee, was sufficient. To say that an arrest is effected by the slightest application of physical force, despite the arrestee's escape, is not to say that for Fourth Amendment purposes there is a continuing arrest during the period of fugitivity. If, for example, Pertoso had laid his hands upon Hodari to arrest him, but Hodari had broken away and had then cast away the cocaine, it would hardly be realistic to say that disclosure had been made during the course of an arrest. The present case, however, is even one step further removed. It does not involve the application of a physical force. Hodari was untouched by Officer Pertoso at the time he discarded the cocaine. His defense relies instead upon the proposition that a seizure occurs when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen. Hodari contends, and we accept as true for purposes of this decision, that Pertoso's pursuit qualified as a show of authority, calling upon Hodari to halt. The narrow question before us is whether, with respect to a show of authority, as with respect to application of physical force, a seizure occurs even though the subject does not yield. We hold it does not. The language of the Fourth Amendment, of course, cannot sustain respondents' contention. The word seizure readily bears the meaning of laying on of hands or application of physical force to restrain movement, even when it is ultimately unsuccessful. She seized the purse snatcher, but he broke out of her grasp. It does not remotely apply, however, to the prospect of a policeman yelling, "Stop in the name of the law," at a fleeing form that continues to flee. That is no seizure, nor can the result respondent wishes to achieve be produced, indirectly as it were, by suggesting that Pertoso's uncomplied with show of authority was a common law arrest, and then appealing to the principle that all common law arrests are seizures. An arrest requires either physical force as described above, or, where that is absent, submission to the assertion of authority. We do not think it desirable, even as a policy matter, to stretch the Fourth Amendment beyond its words and beyond the meaning of arrest, as respondent urges. Street pursuits always place the public at some risk, and compliance with police orders to stop should therefore be encouraged. Only a few of those orders, we must presume, will be without adequate basis, and since the addressee has no ready means of identifying the deficient ones, it almost invariably is the responsible course to comply. Unlawful orders will not be deterred, moreover, by sanctioning through the exclusionary rule those of them that are not obeyed. Since policemen do not command stop expecting to be ignored, or give chase hoping to be outrun, it fully suffices to apply the deterrent to their genuine, successful seizures. Respondent contends that his position is sustained by the so-called Mendenhall test. A person has been seized within the meaning of the Fourth Amendment only if, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. In seeking to rely upon that test here, respondent fails to read it carefully. It says that a person has been seized only if, not that he has been seized whenever. It states a necessary, but not a sufficient, condition for seizure, or, more precisely, for seizure effected through a show of authority. Mendenhall establishes that the test for existence of a show of authority is an objective one, not whether the citizen perceived that he was being ordered to restrict his movement, but whether the officer's words and actions would have conveyed that to a reasonable person. In sum, assuming that Pertoso's pursuit in the present case constituted a show of authority, enjoining Hodari to halt, since Hodari did not comply with that injunction, he was not seized until he was tackled. The cocaine abandoned while he was running was in this case not the fruit of the seizure, and his motion to exclude evidence of it was properly denied.